legal. I used to be member legal services attorney. I'm now municipal law attorney here at KLC. In looking at the roster of the attendees today, I see a lot of familiar faces. We have a really good mix of legislative body members, some mayors, and got a couple city attorneys and city clerks, and just kind of a broad spectrum. A lot of what I'm going to be covering is a little bit specific to obviously the elected officials, because this is legislation. I do want to try to cover as much as I can some of the more, I guess, civics class aspects of how to legislate within the city. So with no further ado, let's get into it. I usually do this at City Officials Academy, and the first year I did it, I think I was given 25 minutes. I've got it up to 45 minutes. That's still not enough time. The feedback I got when I did this at the Academy most recently, or a version of this most recently, was that I was talking like I was an auctioneer. So I will try to slow down a little bit because I don't have nearly the time crunch here today, and that I was using too many $10 words. So I will try to speak as clearly and concisely as possible. But I mean, come on, I'm a lawyer. I've got to throw in one or two as I do this. And frankly, a lot of the big words are statutory, so I don't really have a choice. So we're here to talk about how a city legislates. How do y'all get laws passed? And that's going to be through your ordinances, your orders, and resolutions, but not as much because those are non-binding. So this is, if we have some new members here, you've been doing this for a couple months. I realize you're still learning the ropes. As part of my job, I travel from cities to city, from one end of the state to the other. I've yet to see two cities treat ordinances and orders, their adoption and those procedures alike. But there are some general guidelines and some rules that we need to follow with this to make sure that, heaven forbid, something that you take the time and effort to get passed and published is actually binding on the citizens of your community. With that being said, there is no one size fits all. In Kentucky, we have several different forms of government. We have city manager, we have commission, we have mayor council, which is the broadest adopted form. We also have, I see that one of the assigned up attendees is a council member here in Lexington, which is metro form of government under 67C. And they have an entirely different way of doing it. So if I have kind of a flashing disclaimer on what we're going to be talking today, in law school, we always learn that, check your local rules. There are a couple issues that will come up when we talk about it. Some cities adopt beyond what is required by statute as to how they adopt things and do things. If that's the case, you got to follow that. Obviously, a city council form of government is going to be different than a commission or city manager form of government as far as how and when some actions are going to be triggered, most notably in signing of an ordinance once it's passed. Is there a veto? So we'll get into that a little bit. But first of all, sorry guys, we're going to have a quick pop quiz on a couple questions, just kind of see familiarity we have with this. And since it's St. Patrick's Day, I want to kind of have some fun with this. So first of all, Carl the Cluricon. Cluricon is a cousin of a leprechaun. I went through a stage in high school and college where I read a lot of William Butler Yeats, who was a fabulous Irish poet. But part of what he did was there was a period of time where the Gaelic language was outlawed by England as part of the occupation. And the verbal history of the folk tales was being lost. So he actually traveled the country and gathered all these folk tales, the fairy tales locally. And Cluricon, there's not a pot of gold that you're going to get from it. But if you ever get a Cluricon infestation, for lack of a better way of putting it, they're going to sneak into your wine cellar and drink all your wine. So in this situation, Carl is a city employee, and he's broken into the city's wine cellar and liquor cellar and drank all of the liquor there. Nothing left. What would be the proper avenue to discipline? And Cassie, if you could open that up for them to be able to vote on that.
It's open.
Oh, it is? Okay. Let's see. Oh, host and panelists cannot vote. I see that. Good deal. Secondly, Mayor Maloney wants to mandate procedures in City Hall for better protection of the city's goal. What would be the best way for Mayor Maloney to do that? And is that up, Cassie? There we go. Give you all a minute or two to do that. And finally, hurling, which is the national sport of Ireland. Your city's team has just won the county hurling championship. How would your city recognize such a fabulous, fabulous championship at the local level? Okay, and there's not really any really wrong answers here. Well, there are, but we're going to talk about sort of the best avenues as we work through this a little bit here today. So an executive order, we're going to talk about this first. And I mentioned earlier, check your local rules and check your local application, because if you're a city with a mayor council form of government under 83A.130, the executive authority rests with the mayor. And under 130, there are express areas that the mayor has the authority to act as the chief executive and chief administrator within the city. In a commission or city manager form of government, that's a little bit different because it's jointly shared. And really, as far as executive orders and municipal orders, which we'll discuss after executive orders, in commission and city manager form of government, there is a good bit of overlap in that because it's jointly held, it can be somewhat of a one-size-fits-all depending on whatever the city, usually just out of habit, will opt to do. But as far as the definition, it's an order issued by the executive authority of a municipality, which is binding upon the officers and employees and any governmental agency over which the municipality has jurisdiction. So generally, these are used to make regulations as the executive or chief administrator, to appoint members to boards, which depending upon the board or commission, the mayor would have appointment authority, depending upon what statute controls with that, and to convey administrative decisions made by the mayor as a chief administrative officer, or if it's a situation where the commission or the city man or the board of commissioners jointly holds that, it can be done in that manner. For the clerks on the call, I see there's about 10 of y'all. I think y'all know this. It's fairly common sense. The biggest thing is there's no publication requirement with this. There's no requirement for a first and second reading. It just has to be in writing. It has to be sequentially numbered and kept as part of your permanent file. But there's no particular form required. You're not going to get yelled at or beaten on if you have your own special way of doing it, as long as you're consistent with how it's being done. It becomes effective upon adopted, and if it's obviously something going to be signed by your mayor, that would be effective upon his or her signature. And as with any order or resolution or ordinance, like addresses like. So if you've done something by executive order, it needs to be repealed or amended through a subsequent executive order. As for a municipal order, it's similar, but it has to do more with the legislative body's authority. And under 83A.130 in the mayor council form of government, the legislative body, the council, does have some express authority as part of that. So this would be an official act of the legislative body of a municipality, which is binding upon the officers and employees of the municipality and any governmental agency over which the municipality has jurisdiction. So these are normally internal operations and functions of a municipality. A lot of times setting of holidays are done in this manner, and the appointment or removal of certain members of boards and commission, because there are boards and commissions where the council does have appointment authority. They're rare, but they are out there. One of the issues with this is that it can never be used where an ordinance would be required. So I know that every city I talk to is always trying to find ways to save money, but you can't save money by doing something that has to be done as an ordinance by doing it as an order. So that's something to keep in mind. And also, as far as in talking about Carl the Clericon, in most cases, in KLC's best practice through Andrea Schindelbauer in our personnel department, is if there's dismissal or suspension or reprimands, demotions, things like that, we prefer that this be done by municipal order to be made part of the permanent record with this. One of the differences between an executive order and municipal order is that it is required to be adopted at an official meeting of the city. So it's going to have to be adopted at a regular or specially called meeting. It's going to require a consensus of the body in order to get this adopted. But other than that, it's the same requirements as an executive order. It is effective upon its adoption. And as same with an executive order, it can be amended or repealed only through a subsequent municipal order. So again, like treated as like. Resolutions to honor the city hurling team. JD for years has said this is kind of the fluffy stuff. They're non-binding. I somewhat jokingly say sometimes they're not worth the paper they're written on, but they're important to show a city's train of thought, a city's intent in an area. So oftentimes during legislative session, you'll receive emails from KLC saying, on this bill that we've got before the legislature, will you please pass a resolution saying we need this? So that's very important. Always pay attention to those. Those are fantastic. But if it's the city Little League team, if it is somebody's 50th year of being Santa Claus in the Christmas parade, things like that. Those are, or I guess St. Patrick or a leprechaun in the St. Patrick's Day parade, depending on the holiday. That's the way of doing it. There's no particular form. There's no requirement for adoption. I get calls about people wanting to have proclamations to recognize somebody's long-time service to the city. Well, that's really just a resolution. And I've told clerks in the past that feel free to get out your calligraphy set and make it as pretty and as ornate with gold leaf as you want, because there's no particular form or function with it. I mean, it just has to be adopted, usually by a voice vote. There's no real parameters with this. But that's, resolutions are important because they're usually used for identifying formal positions you may take on a legislative subject. We get calls. It was a hot topic about a year or two ago about sanctuary cities and sanctuary cities for Second Amendment. And a lot of city attorneys were calling on this, and I think most cities did address this as a resolution, because these are items that are handled at the federal level, somewhat at the state level. It's a good position for a city to state their political opinion on broader political issues with this. If you need to study, for instance, a traffic issue on Main Street, as far as, do we need to take action here? This resolution is a good idea to say, hey, we're going to appoint a committee and do this. So it's a good way to sort of throw down a marker to say this is an issue that we're wanting to look at. So those are the three areas as far as orders and resolutions to discuss. But we want to talk about what ordinances are, because the city speaks loudest through an ordinance. There's more legal requirements for getting these passed, and it's a permanent binding measure that a city can take to weigh in on local law or the appropriation of money. So you do this to communicate, regulate, and maintain and enhance the police powers, which is the health, safety, and welfare of your community. The analogy I like to use when you're doing ordinances is, think of it like the old movies that had the town crier. It is how you announce to your citizens what the law of the land is, and the land being, every territory within the city limits. They're permanent binding, and they're the rule of law, as I said. They establish local laws and regulations. You pass a budget ordinance to appropriate funds once a year, at least I hope you do. And there are some areas that are specially required by statute to have an ordinance, such as if you're looking to annex territory, this has to be done by ordinance. The budget adoption, as I mentioned earlier, city has to have an ethics code, which has to be done by ordinance. There are several areas under KRS that this is required. They are subordinate to state law, so you can't supplant what the legislature has said in an area. Now you can kind of go on parallel tracks. We'll talk about that. But if there is a direct conflict, the concept of preemption would apply. And preemption essentially means that the state has so flooded the field, so to speak, that the city doesn't really have much of an area to legislate in, city or county, depending on what it is on a state level. But home rule under 82.082 still has its role, because a city can still exercise any power or perform any function that is not in conflict with a constitutional federal state power or provision. A power or function is in conflict if it's expressly prohibited by statute. So if the state says you can't do that and you do it, you can't do it. or if it's a comprehensive legislative scheme. And people ask me all the time, what is this? The best example I can give is the state alcohol statutes, not just because that's kind of my area of expertise here at KLC, but it constitutes 441, KRS 441 to 444. So that's 4 sections of the Kentucky Revised Statute that is dedicated to alcohol. I think by even the most layman of legal knowledge that a person has, is pretty clear to say that the state has spoken very loudly and broadly and expressly as far as what can and cannot be done in the area of alcohol. And there are other similar areas where this is the case. Most recently, I guess it's not that most recently, time kind of flies, we had some cities that were attempting to pass local minimum wage requirements because on appeal, this was held by the Kentucky Supreme Court to be preempted because the wage statutes in Kentucky were a comprehensive legislative scheme with that. So that's just something to keep in mind depending upon the topic area. An example of this would be that even though something may be preempted, it doesn't mean that a city can't pass ordinances that are in addition to, yet not inconsistent with those state statutes. The case I cite here has to do with nude dancing, and that's a popular area of regulation in our cities, oftentimes with alcohol enforcement. And that's exactly what the case held, was that yes, there are parameters under the enforcement of lewd behavior or alcohol. This is just in addition to, and there's nothing statutorily that preempts a city from doing that. So that's something to keep in mind, that there are areas where you can extend out what can be done with this. The mere fact that the state has made certain regulations in an area doesn't necessarily preempt a city from doing more. The case of Commonwealth v. Doe that I cite here has to do with state lead requirements, lead paint requirements, which 20, 30 years ago was a huge issue. And in that area, this is a county case, it's not a city case, but the county tacked on additional requirements over and above what the state required, and it was challenged by a local builder. And what the Kentucky Supreme Court said was that the very language in the statute, in fact, encouraged cities and counties to adopt more stringent local regulations in this area. So, just because the state may have statutes in an area doesn't necessarily mean that you're absolutely prohibited from acting. So 9 times out of 10, the test is going to be, is there a conflict? Is the state statute saying A and you're wanting to do Z? If you're going 180 degrees in opposite directions, it's probably going to be an issue. Another thing that you want to do in drafting, due diligence, this is why you have your city attorney. If you're looking to get into an area that may be new or novel, take some time to make sure that what you all are proposing to do doesn't run in conflict. The big area this comes up, I grew up in Ashland. Ashland has several cases back from the 80s and 90s where they tried in several different ways to regulate alcohol differently than what was envisioned by 441 to 444. And in every single case, the appellate court said, Ashland, we respect the hustle. We like what you're doing here, but you can't do that because it's a clear preemption issue. So as far as drafting an ordinance, how do you get pen to paper? And I get asked, well, I'm just a legislator. Can I present something? Or I'm the mayor. Can I present something? Or does it have to be written by the city attorney? The answer is yes to all of those. I think it makes sense that if you're going to be proposing something, though, you have your city attorney look at it prior to it being introduced, just to make sure that all the I's are dotted and T's are crossed from a structure standpoint. And because strict compliance with the requirements of 83A.060 are in place. It's not horseshoes, it's not hand grenades. Close ain't good enough. We'll see why here in a moment. It has to be precisely drafted and readily accessible. And frankly, a lot of the issues I see where a layman, someone without a legal background, and frankly, even lawyers, it's even worse sometimes, is I really am not a fan of legalese at all. Any of y'all that deal with me, I'm very plain spoken, even when I'm making the legal argument, because what ultimately are we doing? We're communicating with our citizens. So if we word something using those $10 words I was accused of using at COA, you're not telling your citizens what they need to know in order to comply with the law. Heaven forbid, they have some idea as far as what the state, I'm sorry, not the state, what the city requires as far as how my yard has to be kept up under the nuisance ordinance, or what hours can my restaurant operate, a whole raft of things. If you draft an ordinance and Joe off the street can't read it and tell you what it means and what its intent is, you need to go back and rewrite it. Substantial compliance is just a fancy way of saying that if there is close enough, that's not going to work. A local legislative body to enact a valid ordinance has to observe all the requirements. And I mentioned earlier, look at your local rules. Some cities require by local ordinance or order to take a vote after the first reading. That's not statutorily required. We'll talk about that as we go through this a little bit. But if that is a local requirement, and for whatever reason you all don't do that, you can get overturned on appeal. So it's important not just to know what the requirement is under the statute, but any additional local controls or procedural controls you have in place as far as what you may require that is over and above what is required by state statute. As far as enacting an ordinance, what are the requirements for it? Well, it has to be in writing. It has to only cover one subject. So you can't cover garbage pickup and hours the pool is going to be open in the same ordinance. It's got to be one subject or one subject area only. And it's got to clearly state what it does. It can't be a situation where you say you're talking about, hours for restaurants to be open and sell alcohol and have it be your city's ethics ordinance. So, again, town crier. You want the community to know what it is you're talking about. And there is a requirement that it does have an enacting clause, which is just simply a phrase that says, be it ordained by the city of, I use Blarney here in keeping with the subject matter, but just whatever your city is. And there is actually a case out of Erlanger that the failure to do so could lead to it being declared void. Now, this was dicta in the case, which is a fancy way of saying the judge talking just to hear themselves talk. So that the case wasn't decided on the lack of that, but it is suggested that failure to have that could be problematic. So you want to make sure that, again, you're dotting I's and crossing T's, and this is why you have your city attorney for these issues. The whereas clause, and this is my donkey in a blanket for reasons you'll see here in a moment. It's useful to state the purpose of what is the reasoning behind why you're doing something. It's not in the main body of the ordinance. It's in the preamble. It's after the ordinance title, but before the enacting clause. Because again, I'm a lawyer. I was an appellate attorney for most of my career. I'm a huge believer in having a record, and I'm an even stronger believer in having something and not needing it than needing and not having it. Because you'd be surprised how many times I get calls from cities that say, "Well, we did this." Okay, why did you do this? Well, we did it because of this. Okay, did you get this in the ordinance or the emergency, declaration for why you're purchasing something without bidding it? Well, no. Well, what have you done? Well, if you get challenged at that, you're essentially having to perfect a record after the fact. And I've seen plaintiffs' attorneys in depositions that can make that entirely innocent action by the city look really bad. They get paid to do that. And I'm sure some of y'all probably sat in a deposition. They ain't fun. I used to have to take depositions for a time period when I was an insurance defense counsel. I hated them. They're not pleasant. I would rather have root canals than do that. So the donkey blanket is a good way. It's also an ass cover. Depending on how you look at it. And that's what they're there for. It's there to where a city, especially if it's an area where you think you're going to have pushback or God forbid, a legal challenge. What you have done is you've created a record as to what the thoughts and the processes were in the city at the time you were going to do this, especially if it's an emergency proclamation. And a little bit off topic with procurement. I've gotten a lot of calls given the flooding in Eastern Kentucky and some of the damage with that. I'm generally not a fan of declaring emergencies for purchasing, but if you have a flood and something has to be done for the health, safety, and welfare of your community, yes, the mayor as the chief executive can declare that, but you need to have a lot of whereas clauses in there, and frankly, it probably needs to be drafted by your city attorney to really create the record to where if it is challenged as to what the thought process and the necessity and the exigent circumstances were as to why this was needed. Savings and severability clause. This was probably, it's old news to the other attorneys on this. Savings clause is just a fancy way of saying that if a couple years ago when the code enforcement and nuisance was changed by legislation, is that if you are amending or adopting a new ordinance in the same area, and it's something that has an enforcement mechanism like code enforcement, that if you adopt a new ordinance, any of the ongoing prosecutions or administrative actions under the old ordinance can still continue. So it's just that it saves any of the enforcement actions that are currently in the pipeline. And severability, I think we've all kind of learned a lot about this with the Obamacare and a lot of the legislation, a lot of the cases that have been winding their way through, and well, they're trying to get it thrown out because of this, and then the government always says, well, but it's severable, and it's just a fancy way of saying that if for whatever reason an aspect or a portion of an ordinance or a statute on the state or federal level is ruled unconstitutional or been done improperly, you're not throwing the baby out with the bathwater. You can sever it out, and then there's oftentimes that raises another legal argument as to whether something really is or is not severable, and have you knocked out too many legs under the table to where it will still stand out if you take that. But that's all that is. If your city uses AmLegal or Municode as far as your codification service, there is just a general savings and severability language as part of your municipal code. So that's not needed in every one. And there's also, as far as savings and severability, depending on the subject matter, you may not need it in every ordinance, but it is something to be aware of. Especially if it's something like code enforcement, you're probably going to need a savings clause. And if it's something that you anticipate having a lot of litigation over, my default would be, I think probably having severability and savings and severability in each ordinance, again, in consultation with your city attorney, is probably something to be aware of, and it's probably a good practice to have in order to discuss this. As far as introduction, this is a question we get asked a lot, because in the mayor council form of government, the mayor is the chief executive and the chief administrative officer. She is not a member of the legislative body. However, again, I've traveled to a lot of cities, and it is not uncommon to see the mayor bring up, in a mayor council form of government, the mayor bring up an ordinance, or the city attorney bring up an ordinance, or the city clerk bring up an ordinance, and just sort of bring it out on the floor. And then the council, as a legislative body, starts, it's usually adopted, or somebody makes a motion that they take it up and there's a second, and then it proceeds from there. I get asked, well, if that's the case, well, how do we stop the mayor from doing this? If you do, you may not want to, and obviously if it's a commission form of government or board of commission form of government, the mayor is a full voting member of the legislative body, so it's not an issue. But if you are in a city as a legislative body member, as a council member, and again, honestly, under Lexington Fayette, I know you all have some particular ways of doing things. This may not pertain to how the introduction in Lexington takes place, but for the other 83 8.130 cities, it has happened from time to time to where the council says, we don't want to take this up. We don't want to even, have this on the floor. Well, the option in that situation is if the clerk or the city attorney or the mayor or somebody brings it forward and there are crickets in response, there's no motion made to take it up, there's no second, the legislative body just sits on its hands and refuses to do anything, well, it's never introduced by the legislative body, and it fails for lack of a sponsor or lack of a motion to take it up. However, I also get calls sometimes about, well, we weren't really sure if this was introduced properly, or, the city clerk brought it up, and, the record may be a little unclear as to whether or not there was a motion made to take it up, or a motion for discussion or something like that. That OAG opinion I cite does state that if it's introduced or by ever means, and at some point the council votes on it and passes it and it's published, that cures any issue with how it was introduced. So, if it's kind of going along to get along, if the council says, okay, well, man, it wasn't really introduced right, but you vote on it and pass it, and it's published, well, that kind of removes any argument that you were harmed in that because you voted for it. But I do think in situations where, just out of rote or out of general practice, cities get kind of loosey-goosey with how these are brought to the floor. It's important to keep in mind that as a legislative body of a council in a council meeting, that, you all get to determine what you take up and when you take it up. So that's kind of just a little bit of news you can use with that. As far as the first reading, it's introduced when it's given its first reading at a public meeting, again, town crier aspects of it. It can be done with just an ordinance and a reading of a summary. Again, I've attended a lot of meetings. I've sat through many readings of the entire text of an ordinance at its first reading. There's nothing wrong with that. I think that is absolutely transparency at the local government level, but it's not required. It is a brief narrative. If you are doing a summary that is prepared under the supervision of your city attorney, again, I think that, if your city clerk is preparing this, it has to be run under the nose of your city attorney. And it needs to be written in a way, again, not using $10 words. You need to write it in such a way that Joe on the street is going to be able to pick it up, look at it and say, oh, okay, you all are talking about, looking at what the sewer rates are going to be this year, or, whatever the subject matter is. This is something that's common practice, and there's nothing statutory that requires having a vote after a first reading, but it is a good way to count chickens. If you're taking up an issue that could be politically fraught, for lack of a better way of putting it, it may be worth it to kind of see, if it's no votes for and 6 votes against, well, that's a good indication of how things are going to go. But it's a good way to determine support. It's a good way to determine if you're going to need to whip votes to get, if it's 3-3, how may you get to do that? I do think in the majority of our cities that there is not a vote after the first reading, but again, this is one sort of home court rules. You can kind of do it any way you see fit, and I've seen it done both ways. But it is important to keep in mind that, if it's a situation where you normally would have a first reading on it, and it's something that you all have adopted by ordinance that requires it, and you don't do it, it could be problematic if that ordinance is challenged down the road. Second reading, it has to be done on 2 calendar days. I get asked oftentimes, well, is it like a special meeting? It has to be done 24 hours after the first reading. Absolutely not. 2 calendar days. And what has happened from time to time is, and it's rare, but I have seen cities that will have their specially called meeting at 11:30 p.m. and then a second called meeting for, say, 12:15 a.m. In order to have the readings on 2 separate calendar days. That's rare that happens, but it happens, depending on, if it's something that absolutely positively has to get passed and is not an emergency that you can just have 1 reading. Oftentimes it's between me, you, and the fence post, it's oftentimes something that maybe the city attorney has forgot to get filed, or somebody's forgot to get filed with the state. But that is something there. Also get asked, that Chris, we had the first reading of this back in January. We had bad weather in February, or something came up that we had to handle in February. Is it okay to have the second reading in March? Absolutely. By statute, there is no deadline by which that second reading has to take place. I have had cities that have had a first reading of an ordinance and discovered, years after the fact, literally, that, yeah, we had a first reading on this. Can we go ahead and have a second reading on it? Yes and no. I mean, if the first reading was so long ago that the ordinance could buy itself a drink in a bar, probably don't want to do that. And honestly, again, I defer to local council's judgment on this. But if it's been a pretty long period of time, I think discretion being a better part of valor would argue for going back and having another first reading of this. Just so, again, town crier, you want to let the public know uh, what you're discussing here. And as far as in your community, what that time frame is, as far as when that might be done, that discretion is left with the city to make that determination in consultation with your city attorney. This happens often too, that between the first and second readings, there'll be some textual changes. This is another area where thankfully, I'm all too happy to defer to local counsel as well, because the statute reads and the case law reads that only a substantial and material change requires another first reading. What is substantial and material? Well, it's sort of like beauty. It's in the eye of the beholder. I can tell you, I've attended some meetings to where they've had the first reading and there's a floor amendment that is made, at the time of the second reading. That duck that walked and quacked and swam like a duck all of a sudden is barking like a dog. And that being the case, you may want to go back and have another first reading. But the issue with this, more often than not, is a scrivener's error or just a drafting error. And if it's a punctuation issue or grammatical issue, you're fine. Just correct it and go forward with it. Again, my preference is in talking to cities and city attorneys on this, if it's a situation where you're dealing with money, anything with a dollar sign with it, and you're changing that, probably want to think long and hard about having another first reading on it. Again, though, with not necessarily with your budget, because if you've got the overall budget number and you're moving money within the line items of that overall budget, not as much, because that's part of budget negotiation. But if you're assessing a rate or something like that, to where anytime you're taking money from a taxpayer, that's probably an area to think long and hard as to whether or not somebody that walks in at the first reading and heard it, and then maybe not attend the second reading, recognizes what was passed as an ordinance. And that's what the Farnsley case hinged upon, is that it had changed so much that the very nature of the ordinance had been changed as far as its breadth and scope. So again, town crier, you want to be open, you want to have transparency, and you want to be consistent. So if it's a scrivener's error or something like that, you're probably okay. But if it's a more pervasive change, or you're going in an entirely different direction, again, in consultation with your city attorney, probably want to think about having another first reading of that. Emergencies. Here's my donkey cover again, my donkey blanket, because emergencies they're rare, thankfully. Cities don't normally have to deal with emergencies, but if you do have an emergency, it does waive the need for a second reading. The nature of the emergency has to be stated in the copy of the ordinance, and it has to be declared by 2/3 of the total membership of the legislative body, not just a quorum. So if it's a situation where you have 4 members present of the 6, assuming you're mayor council, you'd need all 4 votes. You wouldn't just need 3 of the 4 in order to do that. So you're going to have to get, I'm sorry, a 2/3 majority. There's a reason I went to law school and not a mathematician. I should know what 2/3 of, whatever 2/3 of the total membership is, which I think is 4, maybe 5. I don't know. Let's assume you have 10 members. You need 6. Let's just do it that way. No, that's not it. 66 of that, 7 votes out of 10. Anyway, okay, I'm getting off that on-ramp that I just went down there. But again, the whereas clauses we talked about. This is important because, again, with your city attorneys drafting and assistance in drafting, you're going to need to spell out exactly what the nature of the emergency is. Because again, if it's an emergency that isn't really an emergency, depending, and we'll get situations where one of the pumps went down at the sewer plant and we're down to only 15% capacity. Clearly areas like that, I think that's an emergency, but you've got to create that record because if it is challenged, you're going to have to show all of the parade of horribles that the city was potentially facing as a result of this. Again, lack of planning on your part does not constitute an emergency on my part. I hate to say this, but the Attorney General has weighed in many times that just because something is a inconvenience, or the city may look bad if you don't do something, doesn't make it an emergency. There is some statutory language, no, I'm sorry, not statutory, some case law language that states that a crisis is an emergency on the outcome of which everything depends. This is out of the city of Pineville, which for years and years had horrible flooding issues due to its location. And I think that is one of the best encapsulations as to what is truly an emergency. It's a crisis is an emergency on the outcome of which everything depends. And so, I mean, you're talking about a real crisis, not just an inconvenience, but something where the health, safety, and welfare of your citizens is really at risk, and you've got to do something now. Because otherwise, in order to call a special meeting, it's just 24 hours. And there are not a lot of things out there that a city could wait 24 hours to act on. That's not to say that, there are some where it's kind of a close call, and 9 times out of 10, the city's probably okay to declare an emergency. But I like to have a firm branch beneath me if I'm crawling out on it. And so I do think, again, talk to your city attorney before you declare an emergency in these areas. Quorum and voting. How do we pass an ordinance once we're talking about it? Well, you've got to record every member's vote. Frankly, I didn't know what an Australian ballot was before I had this job. Australian ballot is the legal term for secret ballot, because we'd have situations, and it would always come up when you had a vacancy on council, that we were wanting to appoint someone to that council seat. But cities would get in their head that, well, it's kind of like an election, so therefore she wouldn't be able to do it by secret ballot or an Australian ballot. No, any action you take as a legislative body member has to be recorded. And in order to pass, it's got to be a quorum of the members present, presuming you have a quorum present to even conduct business. So you're going to at least have to have a quorum, and then a majority of that quorum present, with some exceptions. For instance, in planning and zoning, it requires a majority of the entire legislative body. So even if you have 4 of the 6, you would still need you need 4 votes. So there are a couple areas that by statute you would need. It's based upon the legislative body as a whole. An area that Kentucky law differs from Robert's Rules of Order, and we do have some parliamentarians who are on our councils and commissions that have fought me tooth and nail. And I'm very happy that I have these OAG opinions, the Attorney General opinions, that I can just copy and email to them, because it is different in Kentucky in that an abstention, if you abstain, if you do not cast a vote, you're counted with the majority, however that majority goes. So if you say I abstain because I think I may have a conflict in this, and that my wife or husband is wanting to be this official city caterer, and I don't think I should participate. Well, if your wife or husband is named the city caterer and you abstain, well, then you've cast a vote in their favor. On the flip side of that, if they don't get it, well, then you've voted against your wife or husband in that manner as well. And this is kind of persnickety. I realize that, but we all have those persnickety taxpayers that love to dig and would love to make a mountain out of a molehill. And if they can say, well, you voted in favor of this, well, no, I abstained. Well, under these attorney general's opinions, you in fact did cast a vote in favor of the interest of husband, wife, child, whatever. Does it have a whole lot of legal merit? Probably not, but ounce of prevention, pound of cure. That's why our best practice is, if you have a situation where you think you need to abstain, the far better practice is to get up and remove yourself from the room. If you ain't there, you can't vote. And assuming you've got a quorum present, otherwise, if you're not in the room, then that vote will be tallied without your participation. And then the city clerk or police chief, whoever is there, can come out in the hallway and say, Chris, we're done with this. You can come back in the room and participate in the rest of the meeting. So that's just an important thing to keep in mind. Best practice is just get up and walk out of the room. My wife is a treasury analyst. in one of our ethics trainings that I thought was great, as to, if you're a part of something that you shouldn't be a part of, don't just get up and walk out of the room. Get up and dump your cup of coffee or your water or whatever on the table as you're leaving. So if it's ever questioned after the fact, folks will say, yeah, not only did he leave, he also dumped his water on the table as he was leaving to say he was leaving. So, in this situation, I think as long as it's reflected in the minutes, you're okay. But again, if you're not in the room, you can't cast a vote. So that's important to keep in mind. Mayoral approval. This is a little bit different between commission and board of commission versus council. In the commission and city manager forms, board of commission, it's a purely ministerial act. The mayor has already voted or voted against, depending on what it is. But if a majority passes it, they just sign it because they signed it. But in the mayor council, it's got to be submitted to the mayor for approval, and the mayor then has a couple options. They can sign it, and that's fine. It's got to be signed within 10 days, and then it can be published. Or they can veto it by returning it unsigned with a written explanation as to why they vetoed it. Or finally, they can do nothing. And if a mayor does nothing in a mayor council form of government for 10 days, then it becomes law by operation of law. So after that 10 days, it can then be published. So those are the three options for a mayor and a mayor council form of government. Veto override. It's hard to do because you need one more than the simple majority. So what that means in the mayor council form of government, out of the 6 members, you're going to need 5 to overrule the veto. So that's, so if there are any friends of the mayor on council, at least 2 of them, you got an uphill battle with that. It's got to be done by the second regular meeting after the return of the vetoed ordinance. So it's not something that the mayor can try to grease the skids by saying, not only have I returned this veto, oh, by the way, I'm noticing a special meeting for 24 hours from now and then 48 hours from now. And then after that, my veto stands. No, it's got to be by the regular meeting. So the meeting set by ordinance within your city. This also means that the mayor has no authority to override other actions of the legislative body. So municipal orders, resolutions, motions to form committees, any of those matters, the mayor can't say, no, you can't do that. The veto only applies specifically by law to to ordinances. Publication, no ordinance is effective until publication, and it can be published in full or in summary as designated by the legislative body. I think most cities do this by summary, prepared by an attorney or city attorney in order to save costs. There has been some extension as far as internet posting allowances. If you're in a county of over 80 or 90,000, there are 2 separate things with that. But again, the publication summary has to be prepared by a certified Kentucky licensed attorney. We do have some cities where the council members or the mayor may be an attorney. If that's the case, if they're Kentucky licensed, they can prepare the summary, but again, still run it past your city attorney. It's got to have the ordinance title. It's got to have a brief narrative, again, letting Joe Public know what is in the content of that ordinance so it's clear and understandable. And any section that imposes taxes or fees has to be published in full. So again, anytime you see a $ or you're assessing a tax or fee, that's got to be published in full. And that would just be the relevant subsection or section that imposes those. If you're dealing with annexations or any sort of planning and zoning issues to where you may have a map or plats that are at issue, you don't have to include the descriptions of real property. I'm sorry, would include that, but you could also attach a sketch, drawing, or map in lieu of the meets and bounds description. Because I used to stake hop on a surveying crew in college, and my dad was an engineer. I've never really been able to make heads or tails out of meets and bounds descriptions, and it depends on who drafts them. They're done differently. So if you got a map, show where you're talking about. That can be done in lieu of that. Again, non-emergency ordinances have to be done within 30 days of their enactment, either by mayoral signature or if the 10 days lapses. However, and this has changed recently, because up until about 2 or 3 years ago, I would get calls from city clerks, 1 or 2 of you who may be on this call, who would, call me and say, Chris, just for whatever reason, we didn't get published in time. What are our options? And up until recently, the only option was to go back and redo it. You had to have another first and second reading and pass it again. There was a change that now allows under 424 that if you have 15 days from receiving a registered letter from a citizen saying, hey, dummies, you didn't get this published. So what does that mean in practical standpoint? Well, twice this week, I've had conversations with cities that for whatever reason have discovered that something didn't get published in a timely manner. Well, this is a situation where the city has discovered the error. You haven't received a registered letter, but get it published as soon as possible. So it's no longer kryptonite that's going to kill you for not getting it done. But as soon as you discover these situations where something may not have been published, get it published as soon as possible. Give me a call if this ever comes up. We can talk through it. But just get it published. That's the key aspect of it. Our clerks, who we love, are the official custodian of records for these ordinances, and they're responsible for getting the publications done. We have a lot of online newspapers and free newspapers. Unfortunately, these are still not recognized as newspapers under the requirements of 424.120. There are specific requirements that, as far as circulation and where their headquarters are, and with that will govern where your paper of record is. And frankly, it's going to be the paper you've been using probably since the Eisenhower administration, if not the Teddy Roosevelt administration. So that is something to keep in mind. We're always trying to get this expanded in Frankfort. We're having a little bit more success as far as being able to do things on the internet. But what little money newspapers are making now, they can still buy a raft of lobbyists in Frankfort. So it's an uphill battle, but we're trying. Emergency publication. If you do pass an emergency ordinance, it's got to be published within 10 days of the enactment. So if you do declare an emergency, have that first reading and it's passed, you still got to get it published within 10 days. It's effective upon passage, but you still have to get it published. The effective date, again, it's effective upon publication. However, there are situations that come up oftentimes with maybe tax assessments or license assessments, to where a city says, we're going to make this effective the 1st of next year. So January 1 of 2022, we're going to make this effective. You can do that. That is something that can be done. We see it a lot where folks don't get their ordinance for elected officials passed by the first Monday of the year of election. And they ask and say, Chris, can we fix it now to where we can get the raise now? No. But you can get it passed now, and it's going to be effective as of January 1 of 2023. And you can do that. So you can always specify a future date for this. Indexing and recording for my clerks. I think you all are aware of this responsibility. But at the end of each month, all ordinances which have been adopted have to be indexed and recorded. Again, city budget, tax ordinances, all have to be indexed by fiscal year. All other ordinances have to be kept in a minute book. And in a composite index. However you all do that locally, every city seems to do it a little bit differently, or codified in an ordinance code using AmLegal or Municode or one of those services. You don't have to copy it fully in the minutes for it to be valid. Again, that it just has to be in those composite books and kept as a record. And at least every 5 years, you've got to take a look at it to make sure that everything is still legal within your community. If you've got a buggy whip ordinance, you may want to take a look at repealing that under the circumstances. Amending an ordinance can be done retroactively. Again, any new language has to be underscored, and any stricken language has to be bracketed and struck through. So it's pretty straightforward with that. If you have a code of ordinances, so if you have, city ordinance code section 1-2, you can draft the amendment to cite specifically to that ordinance code section in doing that, but you need to identify the chapter and section as used in the code that you're going to be amending. And again, it's ordinance or section to be repealed has to be clearly identified. So you're going to need to identify the ordinance number when it was passed, the date it was passed, and the title and subject matter. If the ordinance is to be repealed has been amended, you need to repeal those amendments as well. This is more of a best practice because we get people that when they're repealing an ordinance, frankly, get in a hurry and just want to be done with it. Well, they'll say, there's language like any ordinances, on the same subject matter are hereby included. That can be confusing, and especially if you've amended something several times, you may have, sort of a vestigial language in another ordinance somewhere. It's better to pull it out root and branch if you're going to do it. Again, here's some monkeys picking nits, and people say, "Well, you're nitpicking, Chris." Well, how many nits are you comfortable with? I shake my head. I don't want any nits, and it's just again, ounce of prevention being worth a pound of cure. Just be smart about that. If you're using language like all ordinances in conflict are hereby repealed, well, what are those ordinances? Because frankly, you don't know. You haven't done the time to take the time and effort to figure that out. So again, a little bit of time on the front end can save you a ton of time on the back end. If you're going to specifically repeal things, you need to be smart about doing that. Incorporation by reference, oftentimes for like national housing codes or building codes or things like that, you can do that. It's just that you would pass an ordinance that identifies the subject matter. The ordinance has to state that it's adopting the material by reference. So you would make reference to National Housing Code Volume 5 as of January 1, 2021, whatever that edition is that you're using, or iteration of that code, and you've got to attach a copy of it to it. So you would just literally, in your ordinance book, just staple it, paperclip it, make it a part of that, and that's all there is to it. It's very straightforward. Ordinance enforcement, you have basically two options: criminal or civil. And if it's criminal, you have a misdemeanor or a violation by terms of the ordinance. A misdemeanor is a $500 fine and up to 12 months in jail. A violation is a $250 fine. And if the city says, well, this is criminal, but you don't specify, it's a misdemeanor, the default is it's going to be treated as a violation. And that as such, it's going to be prosecuted in district court if it's prosecuted. And unfortunately, the state will get all the money. So it's great. It's great to be law and order. I was an assistant DA and assistant attorney general in Georgia for many, many years. I'm all for law and order. But if you're doing this in assessing a fine, city's not going to see any of the money. So in most cases, it's going to make a lot. And frankly, anything you're treating criminally, there's a good chance it's probably already treated criminally under KRS, under state law. So you're going to be duplicative in that. And you're probably better off to let KRS do that. But if you're going to address it, the civil is going to be the best way of doing it because you have a little more options with it. 83A.065.4 allows cities to impose civil penalties to ensure compliance with ordinances. It can be in lieu or in addition to criminal penalties. It's got to expressly state that a violation shall subject an offender to a civil penalty to be recovered by the city in a civil action in the nature of debt if the offender fails to pay the penalty in prescribed time after the citation. If necessary to seek enforcement of the penalty, the city attorney must pursue the action by filing a petition with the court of appropriate jurisdiction, and the money comes to the city. So that's the key thing to remember. City gets the money. City attorney has to figure out how to get the money, be it code enforcement through a quasi judicial hearing, such as code enforcement or whatever the requirements would be. But you get the money. Along with this, with code enforcement and other areas, you can still assess for continuing violations. So if it just keeps going and going and going, you can keep tacking on if it is a civil violation. And you can also pursue injunctions and abatement orders. So where you can stop or get folks to clean up things that they should be doing. Again, most oftentimes this is done in a code enforcement context, but it's just important to keep in mind that these are levers that you can pull under 83A.065 in order to make sure your streets are clean and the yards are clean, and the matters that your community you're probably getting the most calls about can be addressed. Administrative enforcement, there are some areas of specific statutory schemes that set forth how this can be done. Code enforcement is the main one with this. Cities do have the option for parking citation enforcements. Generally, these are in the larger cities that do this, but it's important to speak to your city attorney or speak to us. I'm currently working on trying to get a library together of all the boards and commissions that a city can create and pulling the relevant statutory language. I've got about 8 or 10 of them. Once the session is over, I want to get all 20 or so that I've identified, and they're going to be available through the KLC website. So hopefully there's going to be a place where you can just look at it and see, what's available for you. Other than that, 3 o'clock on the dot, nailed it. Thank you all so much for your time and your consideration. We got a little bit of time. If anybody has questions, that's fine. If not, that's my contact information. You all have a great day. I hope you all can go out and enjoy some green alcoholic or non-alcoholic beer, or at least some good corned beef and cabbage. And look forward to seeing you all in person soon. Hold on. I think I see maybe 1 or 2 questions here. Chat. Okay, hold on. Oh, okay. Well, thank you, Ms. Hudson. I appreciate that. And Cassie's just telling me stuff I should know anyway. So y'all have a great day. Talk to you soon. Bye-bye.